Welcome to the attendees who are starting to join. We'll give it a minute or so for more people to, pretend you didn't see that happen. We'll give it a minute or so for more people to join in before we get started. Okay, we're at 20 attendees, so I will go ahead and get started. Welcome everyone to this week's congressional briefing on the Indian judiciary and the persecution of minorities. This briefing is brought to you by a coalition of 18 organizations. For some background context on this issue, exactly 3 weeks ago on March 2nd, Wednesday, U.S. Assistant Secretary of State Donald Lu testified before the U.S. Senate's Foreign Affairs Committee. His speech had all the usual talking points of the U.S. government, that India was a close and reliable partner, that it was integral to peace in Asia, etc. And although he mildly acknowledged that the U.S. was, quote unquote, concerned about human rights challenges in India, especially in Jammu and Kashmir, he was quick to add undeserved homilies too. He said, and I quote, "As the world's largest democracy, India has a vibrant civil society, a free media, and an independent judicial system." It is both surprising and disappointing that the United States government is choosing to turn a blind eye to the complete collapse of the democratic order in India under Prime Minister Narendra Modi's hardcore right-wing Hindu majoritarian rule. Not only is Mr. Lu's assertion about a vibrant civil society a lie because the civil society is now being increasingly jailed, but his assertion about India having a free media and an independent judicial system is also laughable because neither is true anymore. In our briefing today, we're going to be examining the increasing subversion of India's judiciary, which now appears to be responding to the diktat of the Modi government. As we saw most recently in the ruling of the Karnataka High Court that upheld an illegal and unconstitutional ban on Muslim students wearing the hijab in schools, India's judiciary is straying from its commitment to providing justice without fear and favor. India's judiciary today is failing to provide justice to Muslims, Christians, Adivasis, Dalits, and human rights defenders who are fighting for rights. While the victims are being sent to jail, denied bail, prosecuted, and convicted, the perpetrators, including the Indian police and politicians, as well as the Hindu majoritarian mobs, are either not tried or acquitted on trial. India's judges today mostly allow the perpetrators of these crimes against minorities to go unpunished and sometimes even rewarded. We saw it with the way Hindu extremist leader Yati Narasimhanand was allowed to walk free after being arrested for telling Hindus to take up weapons against Muslims. And we see constantly in the way everyday hate crimes against Muslims rarely result in serious consequences. Today's panel is made up of some stellar lawyers, academics, and activists who will be shedding more light on this issue. But before that, for some more context, and so you can see just how common it is for anti-minority hatred to go unpunished, we'll be playing a brief video that shows some of the hate crimes and hate speeches made in this past week alone.
Karnataka's High Court upheld a ban on hijabs in schools and colleges, saying it was not an essential religious practice in Islam. Many Muslim girl students have already missed their school exams due to the ban. They will now appeal at the Supreme Court. A Hindu extremist leader from India's ruling BJP party said hijabi girls were terrorists. In Karnataka and Gujarat states, both ruled by the BJP, the governments announced that they would mandatorily include a Hindu religious text in the school curriculum, even though millions of non-Hindu students attend those schools. Islamophobic commuters stopped a hijabi woman with an infant child from taking a seat on a local train in Mumbai. The event came to light after the woman's husband wrote on Twitter that the seat was instead given to a Hindu woman.
India's position on this resolution.
India came out against the UN resolution recognizing an international day to combat Islamophobia. The Indian envoy to the UN said the resolution would divide the world into religious camps. In Moradabad city of Uttar Pradesh, 7 water tanks were painted with the image of soldiers on horses carrying saffron flags. Hindu extremists in the state have grown increasingly bold, and Chief Minister Yogi Adityanath, who won re-election this month, has openly called for the destruction of mosques. Also in Uttar Pradesh, a former BJP state legislator headed a religious rally chanting anti-Muslim slogans and calling for a massacre of Muslims. The mob played loud music right next to a mosque during the prayer. Videos viral of Hindu filmgoers raising slogans against Muslims and calling for their deaths, as well as the abduction and rape of Muslim women. They were watching a propaganda film, Kashmir Files, that falsely accuses Muslims for the killing and exodus of Hindus in Kashmir in 1990. Upper caste Hindus killed a Dalit or lower caste person, Jitendra Megwal, merely because he sported a mustache. Angered that he lived a good lifestyle, the killers rode 500 miles on a two-wheeler and killed him.
So one thing you'll notice about our weekly genocide news videos is that while we report on a lot of hate crimes, it is very rare that we hear that the victims of these crimes have been granted justice. And that is why everything our speakers have to say today is so important. So let's get started with our panel. Our first speaker is Tista Setalvad, who is a senior journalist and human rights defender, best known for her decades-long campaigns against communal hate and violence. She is the co-founder of Communalism Combat, a magazine that takes a deep dive into incidents of communal violence and examines their underlying causes. She also co-founded Sabrang India, an online publication that brings to light injustices and human rights violations. For her outstanding contributions to society, she has received the Padma Shri Award, one of the highest honors in India. So Tista, we're so excited to have you here with us.
Thank you so much for this opportunity. And we are talking on a very somber and difficult subject because we are looking at the way the Indian judiciary looks at one of the most depressed sections of our society. And I'd like to look at it through the lens of our struggle for the survivors of the Gujarat carnage of 2002, because there's so much to say, I thought I would limit it to that. So our experience, and when I say ours, I'm talking about Citizens for Justice and Peace, the organization I represent, of working for the laborious path of justice for the survivors of Gujarat carnage of 2002 has been rocky, filled with the proverbial highs and lows. What has marked this journey was its uniqueness in that, for the first time in post-independent judicial history, we saw the convictions of powerful perpetrators, 170 people, 124 of whom were sent to life imprisonment. However, the question remains, is the struggle for justice in the Gujarat carnage a battle half lost or half won? What have we seen in the last 20 years after the first convictions? We saw overturning of these convictions by the higher courts. We've seen easy bail granted to the perpetrators of the post-Godhra reprisal violence, which took place in over 19 districts, 300 incidents. Besides, and this is something I need to emphasize, just as after the Delhi massacre of large sections of Bengali-speaking Muslims in 1983 and the Sikh mass killings of 1984 in the nation's capital, almost all the police officers guilty of complicity during the 2000 Gujarat carnage and of subversion of the investigation afterwards have been rewarded with promotions and elevations. The handful of officers who swam against the tide and testified have paid very heavily for it. We have one person serving a life imprisonment in jail. We have others who have been facing criminal charges, including the loss of pension. A vindictive state is doing all it can to intimidate and prosecute them post-retirement. There has also been, and this is very important, a differential, if not discriminatory sense of justice between the Godhra accused, that is those accused in the train incident of mass arson on 27 February, and those accused in the post-Godhra reprisal killings, in the grant of bail or award of sentences. And this is something that we need to look at because it also finds an echo in the cases of Bombay 1992-93 and the bomb blast, but I'll stick to Gujarat right here. In 2008, an analysis I wrote about the 84 allegedly accused of the Godhra train burning who had been rotting in the jails for 6 years without one bail hearing in either the High Court or the Supreme Court, brought upon me the ire and the anger of the higher judiciary. Bail is a fundamental and prerequisite inalienable right of every accused. And yet we saw a differential standard being applied to those of the Godhra accused who happen to be Muslim and the post-Godhra accused who happen to be from the non-Muslim community who were involved in brutal reprisal killings. Let's look at what happened in the Godhra case, for instance, after the conviction in 2011. In 2011, the High Court of Gujarat upheld the conviction and also allowed the application for bail. In 2012, the Gujarat High Court rejects the bail applications of all the accused. In comparison, the post-Godhra killings, convictions start happening only in 2011 and 12, but within 4, 5 years, 6 years, 7 years, they're either acquitted by the higher court or they're out on bail. Even today, in 2013, the Supreme Court intervened and got bail for a couple of the Godhra accused. In August 2017, they had to surrender again when the High Court dismissed their appeal. And today, the appeal in the Supreme Court since 2018 has been pending for close to 4 years without a single hearing. So we see, in fact, as we look at, if you look at the lens of bail and jail being an exception and bail being the norm, there's been a differential pattern being applied. Coming back to the struggle for justice for the Gujarat survivors, 20 years on, it appears that sparse institutional lessons have been learned from the 2004 Best Bakery verdict. One jurisprudential breakthrough has been in June 2009 with an amendment to the Criminal Procedure Code, when actually the witness and the complainant were given a right to actually intervene in the trial. That was thanks to our intervention in the Best Bakery case. But many of the gains of this case have been lost because of the failure of the judiciary to sustain any institutional memory from the carnage cases. First of all, going back in time to 2002 and 2003, it was only in July 2003, 17 months after the carnage, and with a star witness in the Best Bakery case making a public allegation of witness intimidation, that the Supreme Court first got shaken up and intervened. A significant marker was April 12, 2004, when we had a landmark judgment, bold pronouncement, when actually strong words were used in the 40-page order of the Supreme Court. And K.G. Kannabarian, a doyen of human rights and an advocate, actually said that the scale, I quote, scale of complicity of the government, the investigation and the prosecution and the courts, including the High Court, was actually pointed out in this order. This judgment, remarkable in its righteous indignation and frankness, regretted the denial of justice to a minority under attack. It also exposed and showcased brilliantly the ills that had beset the criminal justice system. This judgment, Zahira Habibullah Sheikh and another Citizens for Justice and Peace versus State of Gujarat, talked about the modern day Neros who were looking elsewhere when Best Bakery and innocent children were burning and were probably deliberating on how the perpetrators of the crime can be saved or protected. It also drew an equivalence between mob terror and bomb terror. Quote, the fanatics who spread violence in the name of religion are worse than terrorists and more dangerous than an alien enemy. Truer still in the India of 2022. Today, 20 years after the carnage that claimed 2,000 lives in retributory violence following the Godhra mass arson, it is this verdict that we need to revisit, because this verdict that raised important points about the rotting illness of our system, where we saw that the High Court, even public prosecutors, the judgment said that prosecutors function more like defense counsel, investigating agency, perfunctory and far from impartial. These were the comments in the judgment. But did this pronouncement go far enough? And that's the question we need to ask 20 years on. Criminal bouts of communal violence targeted at our religious minorities, sanctioned and sponsored by the state, pose a unique challenge given the inherent conflict of interest. The state is prosecuting the state, and by extension, every officer of the prosecuting state possibly is undertaking every effort to ensure the acquittal of accused officers of the state. Although the Supreme Court in this verdict invoked sections of the Criminal Procedure Code and the Evidence Act that give powers to prosecutors and the courts to function independently, no guidelines were set within this pronouncement to ensure robust institutional recall for the prevention of recurrence. Should not the highest court scathingly underline, as it did, the involvement and complicity of wings of the state government, have laid down guidelines to avoid recurrence? Should it not have set serious, not just guidelines, but pointers to ensure that religion did not enter the sphere of political government? Should it not have laid down a principle for the trial of these cases under the chapter on public tranquility, as K.G. Kannabarian said, read with the Genocide Convention of 1948 to render complete justice, so that wings of the state face an institutional check against pervasive abuse, not just in the Best Bakery case, but in other incidents of mass killing in Gujarat and in the future. We have seen post that perpetrators belonging to the same political dispensation get political power. Post that, we have seen Muzaffarnagar, 2003, Uttar Pradesh. We have seen the attack on minorities through lynchings, and now, of course, the hate speech that is on board. the absence of institutional embedment and recall of the principles of such landmark judicial pronouncements is something that is, I call, the failing institutional memory of our system, that gives us just glimmers of hope every so often, but does not sustain that through the decades ahead. Thank you.
Thank you so much, Tista, for those insightful remarks. We truly appreciate your time here. Next up, for our next panelist, we have Pranay Sumayajala. He is the Advocacy and Outreach Coordinator for Hindus for Human Rights. While studying at the George Washington University's Elliott School of International Affairs, Pranay was a co-founding member of Sunrise GW and helped lead the organization's successful campaign for fossil fuel divestment. Prior to joining Hindus for Human Rights, they were on the board of Students Against Hindutva Ideology, where they served as co-director of research. Pranay, thank you for joining us.
Hi, everyone. Thanks for having me. Thank you for that introduction. My name is Pranay. I'm the Advocacy and Outreach Coordinator, with Hindus for Human Rights. And I'm here today to share the story of Sanjeev Bhatt. Mr. Sanjeev Bhatt, a former officer in the Indian Police Service, is the primary witness and whistleblower to the Gujarat state government's complicit role in the 2002 pogroms, in which thousands of people, mostly Muslims, were killed and injured in horrific communal riots. For over 2 decades, Sanjeev Bhatt has been vindictively victimized and persecuted by the Modi government for not buckling under political pressure and for daring to speak the truth. The judicial persecution of Mr. Bhatt started in 2009, when he first deposed before the Supreme Court appointed special investigation team that was tasked with investigating the violence. The persecution escalated with his deposition before the Nanavati Mehta Commission, which was established to investigate the state's complicity in the 2002 pogrom, as well as his submission of a 2011 affidavit to the Indian Supreme Court and the National Commission of Minorities. In these testimonies, Mr. Bhatt implicated Narendra Modi, who was then the Chief Minister of Gujarat, as well as various other state functionaries in the 2002 anti-Muslim violence. Mr. Bhatt's willingness to speak the truth resulted in his suspension and subsequent dismissal from the Indian Police Service under frivolous grounds of, quote, unauthorized absence from duty, an absence that was caused by his legal obligation to appear and depose before the Nanavati Mehta Commission. However, suspending Mr. Bhatt, dismissing him, unlawfully detaining him for having filed an affidavit, withdrawing his security protection, and unlawfully breaking down his home wasn't enough. On September 5th, 2018, he was detained under the false pretext of questioning in a 3-decade-old case with the sole purpose and intent of silencing and discrediting his voice once and for all. In an attempt to permanently silence and discredit the only person who can link Narendra Modi to the 2002 violence, in a gross miscarriage of justice, Mr. Bhatt was maliciously framed in a 3-decades-old fabricated case, convicted to life imprisonment for a crime he did not commit. In 2018, 2 cases, one 30 years old and the other 26 years old, both of which had previously been investigated, closed, and stayed by the courts, were unlawfully reopened by lower courts in Gujarat at the behest of Narendra Modi and Home Minister Amit Shah, and Sanjeev Bhatt was put under arrest without any documentation or judicial order. It's important to note that in India, for police officers and other public servants to be prosecuted, a sanction to prosecute is required to pursue legal charges. If the sanction has been rejected by the government, it cannot be subjected to review by any other court of law. In 1990, the Gujarati government had refused to give the sanction to prosecute in this case, as the investigation was conducted and closed without any wrongdoing on Mr. Bhatt's part. Thus, this trial in 2018 was proceeded without the appropriate jurisdiction and a blatant violation of due process and basic human rights. Despite Mr. Bhatt's lawyers submitting the stay orders that had been issued in the original case in the 1990s, the court refused to take this evidence into consideration and allowed the Gujarat government to take custody of Mr. Bhatt for whistleblowing. Since 2018, when he was unlawfully detained and subsequently put under arrest, we have seen systematic transfers and special appointments of judges to ensure that Mr. Bhatt is discredited and silenced at all costs. On more than 16 occasions, when his case was listed before judges who would not blindly follow the Modi government's orders, the benches were shuffled the very next day to ensure that the case would be heard by judges keen to act at the government's behest. Any legal officer or judge who tried to dispatch their duty with honesty was immediately punished, while judges who acted at the behest of the government were immediately rewarded with promotions and elevation to favorable positions. One such example was Judicial Magistrate V.R. Charan, who in 2018 refused to turn over Mr. Butt to the police, stating that, quote, there is no justifiable ground to grant police remand as the case in question was investigated and closed in 1995. She dismissed the matter, allowing him to apply for bail the next day. However, this ruling was labeled as a, quote, act of insubordination, and she was immediately transferred overnight. A new judge, D.M. Vyas, was specially appointed in her place to hear the matter, and her ruling was overturned the next day. This is just one chilling example of how the Indian judiciary is used as a puppet machinery by the Modi regime to ensure that the voices of truth and dissent are shackled and silenced. The state judiciary not only falsely framed Mr. Butt on trumped-up charges, but expeditiously conducted the entire trial in his absence, in a farce trial conducted ex parte. When his lawyers requested the court to summon a forensic medicine expert as a defense witness, the court ordered the witness to appear within the next 2 hours, despite the fact they knew the witness lived in an entirely different part of the country and would require at least a day's notice to make the commute. Subsequently, Mr. Butt's team was not allowed to call in a single defense witness or cross-examine the prosecution witnesses. Throughout the trial, the Sessions Court judge fell asleep in open court, and in gross violation of due process, not only blatantly tutored the prosecution witnesses in open court, but also changed the dictation of the testimony to fit the prosecution's fanciful narrative. Ultimately, despite there being no evidence to support the prosecution's allegations in a 30-year-old case that had already been closed, the lower Sessions Court sentenced Mr. Butt to life imprisonment for a crime he did not commit. Once the court convicted him, the judge refused to release the judgment and kept delaying it day after day to ensure that Mr. Butt was not immediately able to challenge the judgment in higher courts. The judge, D.M. Vyas, who had been specially appointed to hear this matter, was immediately rewarded with a promotion to be Law Secretary of Gujarat. On receiving this judgment, finally, Mr. Butt's lawyers filed a special leave petition in the Supreme Court of India challenging this sham trial and the subsequent order for life imprisonment, which was not only based on faulty legal assumptions, but was also even passed illegally without the court having the appropriate sanction to prosecute. Since 2018 and 2019, the petitions filed by Mr. Butt's lawyers in the Supreme Court of India have not been numbered or listed. It's now been 3.5 years since his review petition challenging the vitiated trial has remained in the Supreme Court registry without being numbered. This is not just unprecedented, but absolutely and entirely unheard of. Systematically, all of Mr. Butt's appeals in the Gujarat High Court were only listed before the bench of Justice Bella Trivedi, who is famously sympathetic to Narendra Modi and Amit Shah. Finally, after much delay, when his appeal for bail was finally listed before Justice Trivedi, in an absolute mockery of due process rights, she declared in open court that she would give his lawyers only 5 minutes to argue for his bail. When his lawyers protested this egregious decision, the judge decided to deny bail without even hearing any arguments. She was immediately rewarded with an elevation to the Supreme Court of India, where she currently serves, superseding a dozen of her seniors. For the last 3.5 years, Mr. Sanjeev Butt have been fighting to get just one fair day in court after years of relentless persecution for blowing the whistle on the Gujarat government and Narendra Modi's complicity in the 2002 violence. Until the Indian judiciary is held accountable for their complicit role in the government's attempts to silence and shackle every honest voice holding the regime accountable for their crimes, Indian democracy and defenders of justice and human rights like Mr. Butt will continue to be victimized by the judiciary at the behest of the governing regime. Thank you.
Thank you so much, Pranay. Our next panelist is Reverend Dr. Sarah Anderson Rajarigam, who is a Lutheran pastor serving just outside of Philadelphia. She's attended a few briefings on Capitol Hill as part of a group with Dalit Solidarity Forum, Hindus for Human Rights, Indian American Muslim Council, International Christian Concern, and India Civil Watch International. While a seminarian in India, she was a student of the late Father Stan Swami, who was at the time teaching at Indian Social Institute. Reverend, we're so honored to have you here with us.
Thank you, Safa. And thank you for the opportunity to be here with you all and to share some of our concerns regarding the present government as it continues to hunt down civilians and harass intellectuals, activists, social workers, and ordinary citizens who raise their voice against injustice. Yes, even as we speak, there is persecution of Christians and Dalits, murdering priests, stirring up violence that is going on right now. To add insult to injury and to make things worse, even the Indian judiciary has failed miserably to protect minorities, while the Indian and protecting those who are politically motivated to homogenize the nation through their BJP Hindu nationalistic ideologies. Shame on the Indian judiciary that has not only failed its citizens, and even worse, that it targets and captures human rights defenders. There are many clear examples of this, but I'm just going to focus on the failure of the Indian judiciary to protect minorities and human rights defenders, as that of Father Stan, while he was still in custody, an 84-year-old Jesuit priest. This stain on the record of the Indian judiciary will not be washed off anytime soon. Recently, the Working Group on Arbitrary Detention of the UN Human Rights Council raised the issue of the case with the government of India. The government did not even respond to the submission made by the Human Rights Council, showing the Indian state of disrespect of global human rights mechanisms and norms. The UN Working Group laid out many of the disturbing facts around Father Stan's detention and death, right from the point of investigation report, when his name wasn't even listed, through unlawfully holding and transporting without the bail option. The judiciary has failed on so many levels, where the voice of the human rights defenders is quashed. Where else can the minorities and ordinary citizens turn to for redressal? Let me share some facts related to the failure of the judiciary in actual terms as it occurred in the instance of the death of Father Stan. First, Father Stan was interrogated for over 15 hours in late July and early August of 2020 in the Bhima Koregaon case. This itself is a travesty because Father Stan had nothing to do with Bhima Koregaon incident. He was not present at either the event that took place, nor was he present during the violence that occurred around the event. Indeed, the UN Working Group's opinion notes that Father Stan's name had not appeared in the first investigation report lodged under the Bhima Koregaon case, nor was he called for any inquiry or interrogation when 5 human rights defenders were arrested in connection to the case on June 2018. Second, 6 weeks later, Father Stan was forced to accompany officials of the National Investigation Agency, who neither had a warrant nor proof of any other decision by a public authority. They were not wearing uniforms and they did not have any clear identification tags, nor were they the same officers who had interrogated Father Stan. The NIA falsely claimed that Father Stan's lawyer was present at the time of his arrest. The lawyer only met with the NIA officials later that night, after learning of Father Stan's abduction by NIA officials. No charge sheet was filed at the time of Father Stan's arrest. The charge sheet was only filed the next day. Thirdly, the NIA illegally flew Father Stan from Ranchi to Mumbai, despite his protests that his fragile health and his pre-existing condition of Parkinson's disease made it difficult for him to travel. Father Swami was not even brought before any jurisdiction magistrate to obtain a transit demand before undertaking air travel, which is in violation of Indian law. In spite of the fact that Father Stan had cooperated fully with the investigation, and even though the NIA's own filings did not at any point claim that Father Stan was a flight risk or that he had in any way obstructed the investigations, Father Stan was still deprived of his freedom on October 9, 2020. The special NIA court in Mumbai also failed to provide bail relief to Father Stan on 22nd October, in spite of all of these mitigating factors. In spite of Father Stan's fragile conditions and advanced age, the NIA court in Mumbai on 26th November refused to provide Father Stan with winter clothes, nor with a straw or a sipper to drink water from, because his hands were shaky due to his Parkinson's. It was only after a huge public and international outcry that a sipper cup was provided to Father Stan, and this was on November 29 by the jail authorities. The special NIA court failed to provide bail relief to Father Stan on 2 further occasions, on November 26th and December 10th. In spite of the outbreak of COVID pandemic and the certainty of Father Stan's health, his deteriorating conditions in the crowded and unsanitary conditions in the jail, the NIA court in Mumbai again and again rejected his bail petition on as early as 22nd of March, 2021. By the time Father Stan challenged the denial of medical bail with the Bombay High Court, his health had deteriorated sharply and he had contracted COVID. As a result, the Bombay High Court asked for Father Stan to be shifted to a hospital for care, though he wasn't granted bail. By the time the next date on the question of bail for Father Stan, he actually passed away on July 5th, while he was still in custody. Justice had come too late for Father Stan. Like many others, Father Stan's case shows a very clear pattern of judicial failure to safeguard the rights of Indian citizens and human rights defenders in the face of persecution by the state. That so many adverse rulings come from the special NIA court in Mumbai is not an accident. As the UN opinion notes, the case was specifically moved to that court from the NIA court in Pune, even though the case could have been continued at the designated NIA courts in Pune. While the Bombay High Court did provide some relief that the lower courts failed to defend the rights of Father Stan, these are matters of deep concern. And the Bombay High Court has itself failed to provide bail relief to other senior human rights defenders arrested under the same case. In the context of the draconian laws like the Unlawful Activities Prevention Act and the law against sedition, and at a time of increased persecution of rights defenders by the Indian state on the basis of these laws, the courts have miserably failed to protect minorities and rights defenders. This is why perhaps the Union Working Group defended Father Stan's arrest to be in contravention to the International Convention on Civil and Political Rights, in contravention of the Universal Declaration of Human Rights, and was deemed arbitrary and unfair, very unfair. This is also why the UN Working Group called on the Indian government to provide compensation and reparations to his family in accordance with the international law. So even as we discuss Father Stan's case, 15 others, human rights defenders, remain his co-accused. 13 of those 15 are still in prison, including several of them who are 60s and in their 70s. If we do not urgently raise our voices in condemnation of the failure of the judiciary system and in support of the lives of stalwarts like Father Stan and the other co-accused, they all are going to be at the same kind of risk. And this is deplorable. We thank you so much for your kind hearing and hope that you will stand with us in the trenches, that we all together will see the light of justice dawn in our courts of law, in our judiciary systems, and all this in our time. Thank you.
Thank you so much, Reverend, for those very beautiful and insightful remarks. And our hearts go out to Father Stan Swami's family and to everyone else who knew him. And we hope he receives justice soon, and the rest of his co-accused as well. Our next panelist is actually not able to join us live, but he did take the time to record a few remarks for us. Dr. Mike Ghouse is the founder and president of the Center for Pluralism and International Research Center, and the director at World Muslim Congress, a think tank. And so we'll be playing his remarks right now.
Good morning. I am Mike Ghouse with the Center for Pluralism. We are committed to building cohesive societies. We believe if you can learn to respect the otherness of the other and accept the God-given uniqueness to each one of us, then conflicts fade and solutions emerge. India, my motherland, is going through some tough times right now, with division and discord trickling down from the Prime Minister's office to every aspect of Indian life. The most important pillar of democracy, justice, is crumbling. Here is one such case, the Delhi riots. In the Delhi riots case, the behavior of the judiciary, all the way up from trial court to the Supreme Court, has not inspired confidence in the autonomy and independence of the judiciary. In this case, the Indian police in the national capital of Delhi is pursuing an utterly false case against Muslim leaders such as Umar Khalid and Khalid Saifi, who have been arrested on fake charges of carrying out the violence in February 2020. Through independent investigations, including Amnesty International, it has been repeatedly established that the extremists from among Hindus carried out that violence with the full support of and participation from the uniformed personnel of Delhi police. That violence has occurred in Northeast Delhi while US President Donald Trump was visiting the Indian capital. As is widely known, the violence started shortly after Kapil Mishra, the leader of the BJP Janata Party, which rules India, openly threatened violence against Muslims and others who had been protesting against the Citizenship Act, which is CAA, whose aim is to disenfranchise Indian Muslims and rob them of their citizenship. This issue, in fact, reached the courts even as the fires were raging in New Delhi. Hearing an urgent plea, Justice Muralidhar and a fellow judge of the Delhi High Court ordered the Delhi police to immediately register a case against BJP leader Kapil Mishra and investigate his role in the violence. That very night, in a matter of hours, Judge Muralidhar was transferred out of the High Court. No explanation was given by the India Supreme Court as to why he was transferred in such a hurry. Within days, the replaced judges of the High Court canceled Justice Muralidhar's order to the police to file a first information report, or the FIR, against the BJP leader Mishra and others. To this day, Mishra has not been investigated and the police has not filed a case against him. Emboldened by the court's response, the Delhi police eventually filed false criminal cases against Harsh Mandir, a globally renowned Indian human rights defender who has recently been nominated for the Nobel Prize and who had been the petitioner seeking police action against the BJP leader Mishra. In passing his order on BJP leader Mishra, Justice Muralidhar had viewed video clips of the speech that Mishra had made, openly threatening violence. Incredibly, while India's Solicitor General, who is the country's senior most government lawyer, agreed that Mishra's speech was inflammatory, he told the court that it was not conducive time to file the FIR. This, when the police had already registered nearly a dozen FIRs against others, including Muslims, falsely accusing them of violence. What is even more shocking is that when family members of those killed in the violence by the extremists from among Hindus brought their case before the Chief Justice of India, S.A. Bobde, he refused to take any action, either to stop the violence or to order police action against the instigators of the violence, including BJP leader Mishra and BJP parliamentarians Pravesh Verma and Anurag Thakur. Justice Bobde said in the Supreme Court Supreme Court was not equipped to handle that kind of pressure. We cannot stop things from happening. We cannot give preventive relief. We have kind of a pressure on us. All the BJP leaders have continued to walk free. On the other hand, hundreds of Muslims continue to languish in prisons on absurdly false charges of carrying out violence against their own community. As the trial owned up on the lower court since 2020, it became increasingly clear from the proceedings that the police had done an extraordinary, extremely shoddy job. At one point, the police admitted that they did not even have a full recording of speech given by Umar Khalid, a prominent human rights defender and a youth leader, and had only seen a short video clip of his speech. In fact, the full recording of his speech established that Umar Khalid had explicitly eschewed violence and asked the protesters to follow Mahatma Gandhi's path of non-violence. It also became clear that the trial judge, Vinod Yadav, was a no-nonsense judicial officer who would not cut the police any slack. One day he had enough, and he openly chided police in the courtroom, calling the police investigation callous and partial. After a policeman deposing in the court as a witness failed to identify the three alleged rioters, he said the failure of the police to conduct a proper investigation would torment the sentinels of democracy. The judge was incensed that the policemen were lying on oath and giving contradictory statements. He said, "This is a very sorry state of affairs." The judge's exasperation had in fact been building up for months. At one time, he had said that the standard of investigation in a large number of 2020 Northeast riot cases was very poor and will be remembered for police failure. Once he also imposed a fine of rupees 25,000 on a police officer, saying the police have miserably failed in their statutory duties. The Delhi High Court promptly stayed the imposition of that fine. At another time, Judge Yadav observed that the police investigation displayed a complete lack of supervision and was being led in a manner as to protect the accused. He also gave bail to a Muslim man who was accused of joining a Hindu mob killing Muslims. It is very obfuscatory that a Muslim boy would become a part of an unlawful assembly, which mostly consisted members of the Hindu community. The common objective whereof was to cause maximum damage to the property, life, and limbs of the other community, he wrote. After his last observation that the police was casual, callous, and partial, Judge Yadav was transferred. Yes, he was transferred within 24 hours and replaced. This decision was taken by the Chief Justice of the Delhi High Court, without so much as an explanation why he would decide to move a judge in a sensitive case right in the middle of the hearings. The new judge, Amitabh Rawat, has since then been speaking much more favorably to the police. This week, he denied bail to two of the accused Muslim civil rights activists, saying the prima facie he believed the allegations against them were true. He has maintained that line from the day he was assigned to the case over a year ago, saying that prima facie the allegations are true. And how did he arrive at that decision? Judge Rawat said that the protesters had intentionally blocked roads, which caused inconvenience and disrupted supply of essential services. Therefore, their protest qualified to be prosecuted under the draconian anti-terror law called the UAPA. The provisions of UAPA have been rightly invoked in the present case, he said. Incredibly, while the judge has kept saying that the charges are prima facie true, he has refused to allow the defense to discuss the evidence, saying that can only be done in the time of trial. A major part of the prosecution's evidence is WhatsApp chats among the accused. The police say the accused were in control of the protest and therefore they incited the violence. The judges say, yes, that seems to be prima facie true on the basis of WhatsApp chats. But when the defense says that nothing in the WhatsApp chat shows that the incited or talked about violence, the judge says, wait a minute, we cannot discuss this yet because the trial isn't over yet. My friends, in conclusion, the essential pillar of democracy, that is justice, is crumbling in India. The social cohesiveness of the nation is torn apart. Everyone is afraid of each other, and the sense of security among Muslims, Christians, and others is very low. And that is, you are looking at 250 million people. I urge our Congress and President Biden to uplift India by asking Prime Minister Modi not to mess with the judiciary. A nation that is not together and just will not be a reliable ally to the United States. We need to think about it. Thank you.
Special thanks to Dr. Mike for taking the time to record those remarks for us. Our next panelist is Dr. Ellen Kennedy, who is the founder and executive director of World Without Genocide, which provides education about past and current conflicts and advocacy to promote peace and justice. She has received many awards for her work, including the Outstanding Citizen Award from the Anne Frank Center in New York and the Human Rights Award from the UN Office of Church Women United. And she is a member of the Board of Directors of Amnesty International USA. Dr. Kennedy, thank you for joining us.
Thank you. It's an honor to be with all of you today. I speak to you as a Jew with family members who perished in the Holocaust, and that context gives us perspective today. Everything that the Nazis did to persecute Jews and other vulnerable minorities was legal. Over 400 laws were passed and enforced by judiciaries in Germany and in Nazi-occupied countries. After World War II, there were tribunals to prosecute German leaders for crimes. Included among these Nuremberg trials was trial number 3, the Justice case. The defendants were jurists and lawyers in Germany's highest courts. The prosecutors charged them with, quote, judicial murder committed by destroying law and justice in Germany and utilizing the legal process for extermination. In describing these crimes, Chief Prosecution Counsel Telford Taylor remarked, the dagger of the assassin was concealed beneath the robe of the jurist. Judges could have challenged the hundreds of laws. Instead, over the 12 years of Nazi rule, only 3 judges resigned, and not one was dismissed because of refusing to support Nazi ideology. In 1935, Jews were stripped of their citizenship, rendering them stateless. This deprived them of all rights, and paved the way for their murders. I want to focus on India's Citizenship Amendment Act and the National Registry of Citizens. These two policies violate international human rights laws and norms. India is subject to the standards in United Nations documents because India is a party to these covenants and declarations. So let's do a legal review of India's global commitments. January 1942, 47 countries, including India, signed the declaration by the United Nations that resulted in the UN Charter. In 1945, 50 nations adopted that charter. India is a founding member of the UN, and the UN Charter established a system for international peace, security, and promoted, and I quote, respect for human rights and for fundamental freedoms for all, without distinction as to race, sex, language, or religion. India became a member of the first Commission on Human Rights, charged with drafting an international Bill of Rights. The UN document, ratified in 1948, was mentioned earlier. That is the Universal Declaration of Human Rights, the seed of international human rights law today. Article 18 states, everyone has the right to freedom of thought, conscience, and religion, including the right to change his religion or belief, and freedom, either alone or in community, to manifest his religion or belief in teaching, practice, worship, and observance. India was a member of the writing group for that document. The day before ratification of the Universal Declaration, the UN ratified the Genocide Convention, which criminalized genocide as killing, seriously injuring, or attempting to destroy a national, ethnic, racial, or religious group. India ratified the Genocide Convention in 1959. The Genocide Convention was followed by the Geneva Convention that protects rights of civilians, including, quote, their religious convictions and practices. India ratified the Geneva Convention in 1950. It became the fifth country in the world to do so, and the first country in its region. In 1979, India ratified the International Covenant on Civil and Political Rights, which affirms that everyone shall have the right to freedom of thought, conscience, and religion. So India, in its past, has been a world leader in advocating for religious rights and religious freedom. And indeed, these rights are enshrined in Article 25 of India's Constitution. I quote, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. But let's look what has happened under the current practices. In 2019, the current government passed the Citizenship Amendment Act. It grants quick citizenship to people who have fled to India to escape religious persecution in Afghanistan, Pakistan, and Bangladesh. This citizenship is only for refugees who are Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians. It excludes Muslims, including the Rohingya. On Monday, 2 days ago, Secretary of State Antony Blinken labeled the persecution of the Rohingya as genocide. In prohibiting sanctuary for the Rohingya, India is violating its obligations under international law pursuant to the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. The Citizenship Amendment Act, as we have heard, has become a license for anti-Muslim violence with unparalleled mass protests and a nationwide crackdown. Dozens of people have been killed. Protesters from at least 18 human rights organizations have been imprisoned. UN human rights experts have raised concerns about the arrests and have urged release of the activists. The Citizenship Amendment Act was challenged on constitutional grounds. In March 2020, the Supreme Court responded. They stated that the law does not violate the Indian Constitution. I just quoted Article 25. The court justified the exclusion of Muslims, among other groups, stating that India could not be responsible for every persecuted community. Many people hoped that the Supreme Court, when faced with 143 challenges to the Citizenship Amendment Act, would order a temporary stay. The court did not. It has refused as well to hold hearings. The UN High Commissioner for Human Rights has requested to be made a party to the constitutional challenges to the law in the Supreme Court, and she has expressed her concern over its arbitrariness. So this is the first issue, tying citizenship directly to religious faith in a secular country and its support by the highest court in the land. The second issue is removing citizenship and voting rights from Muslims in Assam state. In Assam, a third of the 30 million residents are Muslims. In 2013, India's Supreme Court ordered Assam to conduct a national registry of citizens. The intent to identify and remove people defined as illegal immigrants. An illegal immigrant is, quote, anyone who cannot prove that they or their ancestors entered the country before March 24th, 1971. They will be declared a foreigner and face deportation, unquote. People whose names were not in earlier documents must prove their relationship with listed individuals. And appropriate proof includes land records, bank accounts, government documents, or similar certificates indicating that their ancestors lived in India before that 1971 date. How hard is this? Clerical errors, such as misspelled names, are common in Assam because a third of the population is unable to read. Births and marriages, in addition, often are not registered. The citizen list was released on August 31st, 2019. Nearly 2 million people were left off the registry. People who were excluded were given 120 days to prove their citizenship at foreigners' tribunals. These are judicial tribunals set up to designate people as foreigners. People are not rendered deportable just by being omitted from the registry. They can appeal to these tribunals. There were 36 tribunals. Today, there are more than 100. However, more than 120,000 cases are pending in foreigner tribunals as of December 31st, 2021. If petitioners are unhappy with the tribunal ruling, there are no appeals courts at that level. Amnesty International says that the tribunals are arbitrary. First, despite promises that alleged foreigners would get notice of being alleged of their exclusions, the tribunals are all ex parte. Decisions can be made without petitioners even being present. They may never receive notice from the court. They don't even know that they are being considered for deportation. Second, the judges presiding over the trials have testified that they are, quote, hired on contracts that aren't renewed if they don't brand enough people as foreigners. And then finally, the tribunals appear to discriminate. 9 out of 10 cases were against Muslims, and almost 90% of those Muslims were declared to be illegal immigrants. Foreigners can be held in one of Assam's detention centers. Until recently, they could be detained indefinitely. The Supreme Court now allows detainees who are interned more than 3 years to be released if they can pay a bond that is the equivalent of an average person's 3 years' salary. A Pan-India National Registry Act is now under consideration as well. The Citizenship Amendment Act and the National Registry of Citizens appear to intentionally exclude Muslims. The UN High Commissioner for Human Rights has labeled this fundamentally discriminatory. Without a nationality, a person has no right to have rights. In India today, the Indian judiciary is condemning several million Muslim people with no right to have rights. Thank you.
Dr. Kennedy, thank you so much for your time and for your remarks. We really appreciate you being here. Our next panelist is Mr. Fawaz Shaheen. He is a human rights lawyer and researcher whose work focuses on the intersection of civil liberties and counterterrorism laws, as well as documenting hate crimes and other violations of human rights of minorities. He is also one of the founding members of Innocence Network India, an advocacy group for wrongfully incarcerated persons, especially those belonging to marginalized identities in India. Mr. Shaheen, thank you for joining us today.
Thank you, Safa, and thank you to this coalition for organizing this session. I would like to begin by talking about what is perhaps the most glaring recent example that forces us to question the fetters on judicial independence in India, which is the entire episode that played out in the Delhi High Court during the horrific violence that gripped India's national capital in February 2020. The violence in Northeast District of Delhi was preceded by days of incendiary speeches and open calls to violence against anti-CAA protesters, mostly targeting Muslims, by senior members of the ruling BJP, including a union minister, Anurag Thakur, and elected representatives like Kapil Mishra and Parvesh Verma. As the violence escalated, the High Court of Delhi on 26 February 2020, while hearing a petition seeking the registration of a first information report against these BJP leaders, asked the Delhi police to take a conscious decision to register FIRs in 24 hours. Justice Muralidhar, who was then leading the bench, expressed his anguish that the city is burning and questioned the Delhi police on its delay and its lack of acknowledgement of the hate speeches as crimes in themselves. The Solicitor General of India, appearing for the Delhi police, repeatedly asserted that FIRs will only be registered at an appropriate stage. On 26 February, the Law Ministry published a notification transferring Justice Muralidhar from the Delhi High Court to the Punjab and Haryana High Court. While the transfer order was preceded by an earlier decision of the Supreme Court Collegium, its timing was nothing short of suspicious. The Campaign for Judicial Accountability and Reform had remarked in a statement then that the rushed manner in which the transfer was effected cannot be ignored, and that the transfer was not done in public interest, but only with a view to punishing an honest and courageous judicial officer for simply carrying out his constitutional duties. On 27 February, the matter was reverted to a different bench, and the court gave the government 4 weeks to file a counter in response. To date, no FIR has been registered against these BJP leaders. Instead, as we've heard before, in subsequent months, the special cell of the Delhi police began detaining and arresting a large number of students and activists, many of whom have now been incarcerated for over 2 years. Most of those arrested are young Muslims who had become prominent voices against the controversial Citizenship Amendment Act of 2019. And the thousands of pages of the charge sheet filed against them largely includes details of their participation in the anti-CAA protests, with virtually nothing connecting them to any actual conspiracy concerning the riots. Last year, the Delhi High Court had granted bail to 3 of the 18 accused, Jamia Millia student Asif Iqbal and members of a feminist collective, Natasha Narwal and Devangana Kalita, citing the absence of any material evidence against them. However, the Supreme Court blocked the release of any of their co-accused arrested under similar charges by ruling that the Delhi court's decision could not be cited as a precedent. Courts in India have historically given a wide latitude to state agencies to arrest and incarcerate people in the name of national security concerns, especially when those being accused come from minority or marginalized communities. This has especially been made possible by India's vast array of anti-terrorism laws, the latest iteration of which is the Unlawful Activities Prevention Act, or the UAPA. The law severely constrains an accused's right to obtain bail and allows for prolonged incarceration as the case meanders its way through the courts. Judges are only allowed to give bail to an accused if they are satisfied that no case is made out against them prima facie or at first glance based on evidence collected by the police. It is different from ordinary criminal procedure, and the Supreme Court has further restricted an accused's chances of getting bail when it ruled in the Zahoor Ahmed Watali case in 2019 that courts could not look into the quality of evidence placed before it, but only on whether or not some evidence had been collected against the accused. The Supreme Court has effectively made broad probability rather than a determination of evidence as the basis of seeking bail under UAPA. These laws have led to several instances of unjust incarceration over the years, with one very glaring recent example being the Bhima Koregaon case, about which Reverend Sara was just talking to us, and in which Father Stan Swami was imprisoned, as well as 13 other human rights defenders continue to be in prison. In February 2019, a US-based forensic investigation firm called Arsenal Consulting found that one of those imprisoned in the case, activist Rona Wilson's computer, was hacked using malicious software to plant 10 letters, which the NIA as well as the Pune police have used as primary evidence against her, justifying her arrest. Follow-up reports in subsequent months found that evidence was fabricated in a similar way against at least one other accused, senior lawyer Surinder Gadling. Despite these reports being filed before the courts nearly 3 years ago, the courts have refused to consider this fresh evidence to grant bail, much less to reevaluate the entire case, which obviously seems to be based on flimsy and fabricated grounds. Another worrying development in recent years has been the increasing use of so-called sealed cover jurisprudence, where the Supreme Court as well as lower courts accept evidence filed by state agencies under a sealed cover that is not shared with the accused or with other parties. This practice goes against the basic principles of natural justice and the Indian Supreme Court's own decisions that make the disclosure of all documents with the accused a constitutional mandate. It was heavily relied upon by the Supreme Court in the National Register of Citizens case concerning the state of Assam, which Dr. Kennedy was talking about, in which the court validated the exclusion of as many as 1.9 million people, mostly belonging to the minority Bengali speaking as well as Muslim communities in Assam from the citizenship rolls. It has also been used in many politically sensitive cases, such as the disputed purchase of Rafale fighter jets by the Indian government. Recently, the Kerala High Court also relied on sealed cover evidence provided to it by the Home Ministry to justify the ban on Media One TV, India's only satellite TV news channel that is run by a Muslim management. In a welcome move, the Supreme Court last week placed a stay on the ban, signaling a discomfort with the increasing use of sealed covers. However, until such time as the Supreme Court positively prohibits this practice that has evolved in its own chambers, it continues to be a dangerous weapon that allows the state to skirt public accountability in a judicial forum and raises uncomfortable questions about judicial independence. While Indian courts' reluctance to protect civil liberties in the face of government claims of national security has an unfortunate history, a more recent worrying phenomena has been its tactic of delay and virtual abrogation of responsibility in matters concerning the political agenda of the ruling party. The clearest example of this are the Citizenship Amendment Act, which many decry as unconstitutional, and the abrogation of special status given to the state of Jammu and Kashmir, both of which have been challenged before the Supreme Court, but have been pending without adjudication. Dr. Kennedy already spoke in detail about the CAA, so I won't go on about it, but the one thing that we do need to highlight is while the Act allows people who have been found to be foreigners to be deported, the truth is there is no way to deport them. There's no evidence of them being Bangladeshi nationals as the state claims, and the government of Bangladesh has repeatedly said that it's not ready to take them in. And what it does, what the NRC process has done, and the entire foreigners tribunal process does, is essentially it renders people stateless in their own homes. It reduces them to a bare existence without rights. Before concluding, we cannot fail to mention the recent Karnataka High Court judgment that paves the way for barring hijab-wearing women in educational institutions. We can have a debate over the desirability of the hijab or over how or even why the Karnataka High Court concluded that hijab is not essential to practicing Islam. But we cannot forget that at its core, this is an issue of access to education and specifically the access to educational futures of these Muslim women. The court's complete disregard for how its decision will impact the educational future of thousands of Muslim women and their access to public institutions is the most unfortunate part of the judgment. While many might call us anti-national for speaking about these issues in a public forum, it is precisely our sense of patriotic duty that constrains us to speak. Courts in India are the guardians of our constitutional order, and it is the citizens' faith in the judiciary as an independent and fair guardian that sustains trust in the larger system. In a time of increasing majoritarianism in this plural and diverse country, we hope that the courts will look inwards and reclaim their role of protecting democratic rights and fundamental freedoms of its citizens. Thank you.
Thank you so much, Mr. Shaheen, for those incredibly insightful remarks. And we do wish you the best, and we stand with you as you continue to work towards defending human rights on the ground. And last but not least, we have our final panelist, Kavita Srivastava, who is a veteran human rights activist and feminist in India. In the 1980s, she worked with rural women towards their empowerment in Rajasthan state. And since then, she has worked to ensure justice to survivors of systematic violence due to their gender, class, caste, religious group, or nationality. Her main intervention has been to try setting up mechanisms for justice with the state apparatus and governments in order to build a culture of equality and dignity within governments. Kavita, thank you for joining us.
Yeah, so yes. So I'm going to just try to share some observations which clearly show the failure of the Supreme Court to rise to the occasion to protect the Muslim community which is being targeted. And what the Supreme Court is doing, I don't have to say it, it's been said by so many judges, retired judges, that the Supreme Court is just abdicating its role. We had friends talk about the CA and NRC. So how many petitions went up to the Supreme Court? This is 2019. 140 petitions, and to date have not been heard. So you can imagine how disinterested the Supreme Court is in restoring full citizenship rights. A discriminatory law on citizenship was brought, which excluded Muslims. All the rest would not be treated as illegal migrants, but the Muslims. The only category, other religious categories were excluded. And now 140 petitions lying there, and the Supreme Court is just refusing to hear. Similarly, if you look at what happened with the abrogation of Article 370 in Kashmir. Kashmir had a special status. So in 2019 August, the special status, which was called Article 370, was withdrawn. And to date, the Supreme Court has just no desire to actually restore the culture of constitutionalism, restore the constitutional rights of the people. I mean, after all, this was in the Indian Constitution. More than 30 petitions are in the Supreme Court, and it's just refusing to hear. Similarly, I want to bring two other instances before I move on. The case of, I mean, it's so tragic, but in India, the right to consent, the right to autonomy, the right to marry of my own choice, the right to conversion, these are all fundamental rights. but several states have created, have really taken liberty and completely intruded into this personal decision of mine as to whom I marry, which religion, which faith, my choice of faith. And illegal laws are brought in the name of, they use the term love jihad, meaning that the Muslim man will try to fall in love with a Hindu girl, try to convert her and basically make her into a Muslim. So they call it yet another jihad, So it's jihad in the name of love, elimination of being Hindu in the name of love. So many states like Madhya Pradesh, Gujarat, Uttar Pradesh, Goa, Karnataka, Haryana, several states have passed this law and it's supposed to penalize anybody who converts a Hindu. Now if a Hindu converts a Muslim into Hindu, a Sikh into Hindu, or a Christian into Hindu, that is not going to be considered criminal. But if a Muslim does it, that's the UP law I'm talking about, which is really a draconian law. And in the first month, more than 52 people, men, were arrested. Now, several petitions came up to the Supreme Court. The Supreme Court refused to hear and said, go back to your states. Now I know, so people went back to the states. So it's now pending in the various high courts. So again, the law remains, which will criminalize people's decision, people's autonomy of choosing whom they would like to choose. That law remains. Now this, the Supreme Court, which should have risen to the occasion and settle the matter, refused to do so. It's also very tragic that the Supreme Court in 2019 gave the judgment on Ayodhya and tried to put balm on the Muslim people, after all, a masjid had been broken down by mobs, and they literally legitimized it by stating that, let's, not go back on what's happened. Secularism requires not to go back. It requires to go ahead. And therefore, forget what has happened. We'll give you another space, and granted that space to the Hindu community. That was completely illegal. I won't go into the details. Just telling you the role of the Supreme Court. So of course, it was challenged. A review was put into place in the Supreme Court by some organizations. To date, it has not been heard. It's like 30 years since the Babri Masjid was broken, and till now, actually, Muslims have been completely denied justice. So basically, what I want to state is that that if the Supreme Court of a country is refusing to actually restore the constitutional rights, denies people their fundamental rights, then which court will we go to? Some of the high courts have been doing slightly better, and I'll come to that in a minute. But many a times, those, like Fawaz just said, it overrides the high court judgment. Now, I want to come back to the hijab judgment, and very briefly, I want to state, and it's heartbreaking to see how young girls, they simply went for their right to education, just for the right to education. The classroom, they were not permitted in the classroom. They didn't want a division of the classroom. They only went because they feared that they may not be able to take the exams in the month of March. So they moved court against a circular which was brought post facto. Now, imagine it was an administrative order that the court had to look into, merely an administrative order. The court need not have gone into the question of whether it was essential to the religious practice. It was only supposed to, and as Shahrukh Alam, a lawyer, illustrates that had it been a change of grading midterm, the court would have simply seen the legitimacy of that order. Was it right to have it midterm? Were all the stakeholders, asked about it? Was their opinion taken? It would have looked at it as is done in procedure. But when it came to the hijab, it looked at it purely in religious terms, and just to impose, just the interim order itself was completely violative of people's right to privacy. After all, the hijab was not something that covered the face fully. It's just like what you are wearing, and it was not even something that interrupted in the classroom. It did interrupt the classroom, and it was matching the school dress, the college dress. But the Supreme Court just denied the whole right to education, the whole right to access education, and just somewhere finished that right amongst girls. And the most tragic glimpses that we saw of young girls being made to remove the hijab at the school gate, on the road. Now, it was simply, like being disrobed in public. When the judgment came, the judgment is outrageous, completely outrageous, which not only talks of, hijab is not essential to it, but looks at uniform as uniformity. I mean, how can that ever be accepted? So people rush to the Supreme Court. The Supreme Court till now has not heard it. The girls have missed their exams. I mean, at the end of the day, what is the percentage of Muslims going in? What is the percentage of literacy? It's just 57%. And that's literacy. I mean, higher education is much, much lower. The Supreme Court should have walked much further to have protected that right. The High Court, the Karnataka High Court, should have gone much further, because the entire Karnataka Education Act is built on the principle of secularism, which was completely put aside. And the Supreme Court to date has not seen it, and the girls have missed their exams. So the point that I'm trying to make is that any state government, the executive, has any kind of overreach. It denies our rights. For instance, the UP state brought in this ordinance in the name of security, where they could pick up anybody without even producing, without warrants, without producing to the magistrate. I mean, how can you even do it? But they brought this law, and again, Muslims are picked up in the period of the ordinance, and I mean, it goes on and on. The Supreme Court did intervene a bit when it came to the Public Defacement Act, the arbitrary use of it, and massive penalties being that mostly Muslim protesters of the anti-CAA were fined with. Crores of money was collected, and people were continuously jailed, and notices were given to pay up huge fines. Of course, Supreme Court did put that aside. Though the Supreme Court put it aside, the UP state did not comply by it. So even where the Supreme Court tries to be effective, the executive is ignoring it. So basically, what I want to conclude is that as Justice Shah says, AP Shah, that actually the Supreme Court has given up on its entire tradition of justice, of adhering to principles, and is going the majoritarian way. And not only is it going the majoritarian way, I have not even taken up so many examples. It's not only is it going the majoritarian way, it is actually endorsing it for a fate worse than what the executive is doing at times. There's like the travesty of judicial injustice that also is happening. So basically, this fight that we have to undertake, we need international alliances. This is the way Muslims are being treated. The call for genocide is part of the whole genocide convention. The call I mean, it's nothing to do with them being within an administrative territory of India. It's the duty of everybody outside the country to protect the lives of Muslims today, like we all speaking out against the war in Ukraine. I mean, what other, do we want now the killings to happen? Then we will speak out. I really think internationally accountability needs to be brought towards the government of India, and also, expose what is happening through the Supreme Court. I end here by thanking all of you, and particularly your organization, the Indian American Muslim Council, for continuously doing these briefings. But they must consolidate into more concerted action. India should be made accountable on these principles, on the principles of the Human Rights Declaration, as said by an earlier speaker. Thank you.
Thank you so much, Kavita, and thank you so much to all our panelists and speakers for taking the time to join us, also to record messages for us. And thank you to everyone for joining today. As some food for thought before we wrap up, just remember that even when the courts of the government are compromised, there is still a court of public opinion, one that spans nationalities and borders. And that court, which is run by the general public of the world, needs to stand up now to echo Kavita and everyone else and make it clear to the international community that India's courts need to be checked now, or else further jeopardize the world's largest democracy. To close, I'd like to thank the co-organizers of this briefing, Amnesty International USA, Genocide Watch, 21 Wilberforce, World Without Genocide, Hindus for Human Rights, Indian American Muslim Council, International Christian Concern, Jubilee Campaign, Dalit Solidarity Forum, New York State Council of Churches, Federation of Indian American Christian Organizations of North America, India Civil Watch International, Students Against Hindutva Ideology, Center for Pluralism, American Muslim Institution, International Society for Peace and Justice, Association of Indian Muslims of America, and the Humanism Project. Thank you once again for joining us. Thank you to our panelists, and we will see you all next time.